Hi, good evening. It gives me great pleasure to introduce Professor Graeme Dinwoodie, who is the Professor of Intellectual Property and Information Technology Law at the University of Oxford. He's also Director of the Oxford Intellectual Property Research Centre and the Professorial Fellow of St Peter's College. Prior to taking up the appointment at Oxford, he was Professor of Law and Director of the Program in Intellectual Property Law at the Chicago-Kent College of Law, and held a chair in Intellectual Property Law at Queen Mary College, University of London. He teaches and writes in all aspects of intellectual property law, with an emphasis on the international and comparative aspects of the discipline. And today he will be speaking to us on the topic of mapping marks and markets, the unitary nature of the community trademark.
Thanks, Ian Horn. I'm going to stand so that I can operate the. I'll probably sit when I get to questions. Thanks for that introduction. Thanks for the invitation to come talk. I'll get my pen just a minute. So the topic I have is really all about the unitary nature of the CTM, and the sort of basic doctrinal coverage that I'm going to try and get over is a series of cases that in which the unitary nature has been put at issue in cases before the Court of Justice. So the unitary nature is the focus of what I'm going to talk about, but perhaps towards the end, and I've got pretty firm views on what I think of the cases where the unitary nature of the CTM has been at issue. Towards the end, I want to hopefully have time, we'll just go for about 30 minutes, right? So hopefully have time to suggest that some of the questions that one might think about in working through the problems of the unitary nature of the CTM might tell us something, might be windows into other broader issues about the nature of trademarks in the European system, maybe the nature of trademarks generally, but at least the nature of European trademarks. So the starting point of this is a quote from Advocate General Sharpston from the Leno case that I'll talk a little bit about more in a couple of minutes. The court's decision actually just came down about 8 weeks ago, but this is from the middle of last July when the Advocate General gave her opinion. And she said something that's not particularly controversial in its own terms, which is trademark protection is quintessentially territorial. That's because a trademark is a property right that protects a sign in a defined territory. That statement, however, sort of begs the question, which is, what exactly is the territory to which Advocate General Sharpston is referring? It's perhaps not as obvious in trademark what the answer to that is as it might be in copyright or in patent. You would probably say, consistent with theories of territoriality, well, a British copyright protects you within Britain. A German copyright protects you within Germany. Likewise in the case of patent. And it sort of logically follows from what she's saying, you would think exactly the same in the case of trademarks. I would suggest to you it's a little more complicated in the case of trademarks, because you could define territory in other ways that are entirely logical and consistent with the trademark scheme that don't give you the same answer as Britain or Germany or whatever the relevant country is. And to show you that, I'm going to first put up a quote from the US Supreme Court. You'll see that I'm going to suggest some of these same concerns inform European law. This is a very old quote from the US Supreme Court in 1918, in which they came up with a definition of the scope of protection of a trademark, but a common law trademark, and that's going to be an important part of the analysis, that is defined not by the country's borders, political borders, but in fact defined by the scope of the trade, scope of the use, scope of the goodwill, on the theory that wherever there was trade was the only place there was use, and it was only where use there was reputation, it was only where there was reputation there was goodwill. So essentially the metes and bounds of the property right are defined by wherever the goodwill and the trade went. Now you say, why would you define the territory of a trademark in that way? Well, just quickly to give you the facts, and it really will be very quick from the US case. Basically, you had almost identical marks on identical products in two different parts of the United States. And for those of you who don't know the United States, Massachusetts is nowhere near Louisville, at least it wasn't it's not actually moved physically in the century, but it is at least, I guess, closer conceptually now in that with air travel and the internet and what have you. But in the late 19th century, it was a long way from Massachusetts to Louisville. And these two producers separately marketed their products with the same mark, And then they got into a big fight as to who could use it in Louisville, and the American priority rule is the first to use as a default. And that would have given the rights in Louisville, because they were the first to use in the United States, to Regis, the predecessor, or at United Drug, who succeeded Regis. But in fact, the court held that Mr. Rectenus, in fact, was the person who owned the rights in Louisville, and he actually had the exclusive rights in the Louisville area. And you may say, well, why would he get the rights there? And the reason is that in Louisville, the function of the mark, the source identifying function, was pointing to Mr. Rectenus. It wasn't actually pointing to United Drug, and therefore in order to actually protect the source identification function of the mark in Louisville, you had to define a bit of property around Louisville that belonged to him, and a bit of property in Massachusetts that belonged to United Drug. So what you begin to see is that territory here is meaning something a little bit different than territory the way the Advocate General is using it. So if I can make a friendly amendment it's wonderful to be able to change and amend Advocate General's opinions, but and it is friendly, because I think that Advocate General Sharpson actually has, in 2 or 3 of these cases, come out absolutely perfectly. But I would say that's actually the proper elaboration of the territoriality statement that she was coming up with, which is that it's a trademark registration she was talking about. And once it's a registration, registration is a politically defined act, both in terms of its grant and its enforcement. And the political authority is not this sort of woolly thing somewhere around Louisville, somewhere around Massachusetts. It was the European Union, in this case, the CTM. And so when she was talking about registration, she was talking about, and talking about territory, she was talking about territory in a political sense. And so what I want to draw a distinction, and I'll come back to this, is between 2 different types of territory that exist in trademark law and exist in different mixes in different systems. So the first one is that you have territorial rules that reflect the fact that the rights are granted by authorities, registration authorities, and in that instance, the reason it's territorial is that the sovereignty, the prescriptive authority of the sovereign, runs defined by political borders. You also have an alternative conception of territoriality that is defined by the intrinsic purpose of trademark law, which is to protect a form of signal, the consumer association that grows up. And in that instance, the metes and bounds, how far that reaches, may or may not actually go as far as political borders, and in some cases may transcend political borders. Now you say, well, why does this matter? How is it going to connect to the CTM? I'll bring you back to this slide when we get to a couple of the cases. The reason it's significant in the long term, I want to suggest, is that if what you have is a territorial rule of trademark law that owes its territorial character to the political dimension behind it, either because it's part of national economic or industrial policy, or because it is granted by a national agency, or because it's enforced by national courts whose jurisdiction extends to the borders of the particular nation state, it's going to be pretty fixed to that territory, because in fact those institutions, notwithstanding globalization, are pretty resistant to change. Now obviously we know the CTM is the exception in the European or in the international trademark context, because economic policy is not just set by the British Departments of Trade and Industry or Business, it's set by the Commission. The Minister of Grants no longer the UK IPO, it's OHIM, and the enforcement is CTM courts. And granted, they're national courts, but they're wearing CTM hats. So we've created a series of institutions to try and allow us make this shift in terms of the political scope of our rights. Now, the intrinsic purpose of trademark law, when you're defining, you have a right that reflects that conception of territoriality. Then, in fact, it's going to be less commensurate with the nation-state borders, and it might be very fluid if we have the kind of digital and trade revolution that we've had over the past 20 or 30 years. All right. So I want to suggest there are reasons of significance why this distinction might be significant, and you're going to see it in combination in some of the cases I'll look at in a minute in the CTM. But before we get to the CTM, just to show you this mix actually is endemic perhaps to trademark law generally. This is from an international treaty, the main international treaty foundationally in trademark Paris, which is that you have a conception of a political territoriality embodied in Article 6.1, which is the main expression of territoriality in Paris. But you have an exception from that, or what some people call an exception from that, in terms of well-known marks, which is even though something is not registered, hasn't had the imprimatur of a registration authority, countries are obliged to protect that, which essentially maybe cross-border goodwill. I would suggest that well-known mark doctrine is in fact not an exception to the principle of territoriality. It's just a different conception of territoriality. It's protecting a goodwill that crosses borders rather than something that's defined politically. All right. Now you may say, all right. So why is it a problem to have, or why would you not just sort of pick one or the other? Why would you mix and match these different conceptions of territoriality? Well, if you go back to United Drug, you can understand a little bit why the Americans, at least, decided they had to not just confine themselves to the idea that trademark rights would be territorially defined by goodwill, and that is that trademarks maybe do something other than just protect source identifier signals. They may actually be instruments for expansion of trade. And one of the ways that you might do that is by giving a broader geographic scope and encouraging producers to sell their goods beyond the geographic area in which they currently do. And so, in fact, you even saw the precursor, a hint of that, even in the 1918 case, where the Supreme Court said, well, this is the rule at the moment until Congress acts. And then, sure enough, in 1946, right after the Second World War ended, when the Lanham Act was enacted, the U.S. Congress gave that as one of the reasons for federal legislation. It's not cited very often as the reason for federal legislation. You see the reasons given for the federal legislation in the United States being to protect consumers, protect goodwill. But it was to stimulate and preserve and make easier a national economy in the wake of the Second World War. Now, I highlighted there one word, because I'm going to come back to that in terms of the influence, in terms of, hopefully at the end, European Union, and that is the Americans did it because they believed at that stage they had a national economy, right? They had an integrated national economy, and they wanted to make it easier to enforce and sell goods throughout that integrated economy. One of the things that I think differentiates that 1946 statement from the 1994 statements by the European Commission is that, notwithstanding the fiction legally supported that we have a unitary market, we don't. And that, I think, makes for more problematic applications of these rules in the European context. All right, so with that as an introduction to different conceptions of territoriality, let me turn to the CTM and how this plays out. All right, this is a violation of every PowerPoint rule, so I apologize for those of you who... I'm always having to go up to read it, but basically these are recitals from the trademark regulation. I've given you the 2009 version, but they're the same ones that are in the 1994, just with different numbers, just to make it less convenient for us. They changed the numbering of the recitals. But if you look at the reasons for the regulation, and this is important, it's different than the reasons for the directive. Some of the provisions that are in the directive recitals are the same, but some are different because the CTM did things that the directive did not do. And in particular, if you look at the first couple, right, which is to open up unrestricted economic activity and to facilitate the adaptation of national markets into European-wide markets, you see the regulation is actually an instrument of trade and economic policy, industrial policy, effected by a regional conglomerate that now has political sovereign authority over the whole of the European Union, not just over particular countries. Right? So if you read the first couple of recitals they're essentially the conception that seems to be driving that is a political notion of territoriality. It's trade and economic policy, industrial policy. However, we do have, which has been problematic in any number of other ways, but for these purposes I've got it down to quite short, which is that the regulation does acknowledge that trademark law actually serves a purpose other than that, which is to guarantee the trademark as indication of origin. Now, I'll suggest to you that's driven much more by what I'm calling, though it's a loaded term, the intrinsic purposes of trademark. There are people who would think that actually trade expansion is an intrinsic purpose, but so we might get into my labeling, but I'm calling that a reflection of the intrinsic purpose of trademark law. So you see a slight mix in at least the recitals, the motivations for why we have the regulation. If you look at the substance of the regulation, You likewise would start with the supposition that this is an instrument that is being driven by a political conception of territoriality, rights all over the European Union, unitary in every conceivable way. All right. The question that I want to address exactly is, to what extent is this commitment to political territoriality inevitably going to give way, and have to give way, and appropriately perhaps should give way, to different conceptions when the court is confronted with the fact that trademarks are not just about getting rights over as large a bit of territory as the Commission would like you to get. All right, so to look at that question, I'm going to look at 4 different doctrines. They're all very simple. I'm not going to go into the cases in great detail, other than just to try and identify for you the territorial component to it. The first one is the question of distinctiveness. So these are 2 provisions out of the regulation to do with absolute grounds for denial of trademark registration. And basically the rule is that if the mark for which you seek registration is descriptive, most notably in any part of the community, it shall be denied registration. So if it be descriptive in Finland, but fine everywhere else, that's still enough of a problem to preclude you getting a CTM, right? Because we wouldn't want the Finns to be thinking that some descriptive term that they thought described all products of the type was actually appropriated by a single producer. There is a saving of that, of course, like all descriptive prohibitions, and that is the saving of acquired distinctiveness. However, the question is, what do you have to show by way of acquired distinctiveness in order to overcome that first prohibition in 7.2, which is if it's a problem anywhere, it's a problem for the CTM. And in the case of what then was the court first instance, in the options case, basically I paraphrased in perhaps a little too pithily, I think, maybe there may be more nuance there than that paren actually carries, but that is, but basically everywhere there's a problem, you need to find a solution. So if it's descriptive in Finland, you've got to show acquired distinctiveness in Finland. The problem is, of course, if it's descriptive in 12, 15 countries, you have to show acquired distinctiveness in all of those particular places. The Bovimage case of the Court of Justice essentially affirms that, although that's an odd case because in a Benelux context. Now it's interesting, if you thought about that, and let's just put it in a British context. Let's assume it's just Finland where something's descriptive. There's no Finns here before I slander particular nations. All right, Finland's not a large part of the, I don't know the exact population. It is actually large in terms of what space it occupies, but in terms of population, it's not a large part of the European Union. Let's just say, for purposes of argument, that's about 5%. Maybe more than that, I doubt it. Probably less. But if it's 5%, if you had distinctiveness in 95% of the territory, but not in Finland, in 5%, it would not get you a CTM. Now let me just put that in a British context. I guarantee you that if you were able to show 95% distinctiveness in the United Kingdom, we wouldn't worry the fact that the Western Islands, there's no distinctiveness up there. Right? We wouldn't be remotely concerned about that. So there's something different going on. Now, there's lots of reasons we can get into as to why, something to do with coexistence, as to why that's the case. But this is quite a strict standard that the Court of First Instance and later the Court of Justice has basically adopted in this particular case. Therefore, the vision that they have, I think, of Europe is basically that, right? Which is it's 27 countries stuck together. That's the vision of Europe that the Ford Options rule basically endorses, where it's not necessarily, it's unitary in the sense that if you stick them all together, you get one thing, all right? But it's not particularly integrated. The borders are still evident, all right? Now, they've just begun in the case recently to walk back a little bit from that. It's the case about chocolate bunnies, and if you follow all the blogs, there are a couple of bloggers who are particularly obsessed with trademarks in chocolate bunnies, but this is the one where it's got a little ribbon around the gold foil. They try and get a registration on the shape. Now, as you may know, that's a problem because essentially, although not as a matter of law, a matter of practice, you can't get registrations on product shapes unless you prove acquired distinctiveness. So almost as a matter of law, non-inherently distinctive. So if they are descriptive functionally in every single country of the European Union, that would mean that to get a CTM registration on a product shape, you would have to show that it has been used and acquired distinctiveness in 27 countries. Right? That's quite a hard standard. As a result of which the court, although it ends up in this case still denying the trademark registration, backs off and says, whatever rule we come up with here, we're not suggesting that in the case of shapes, you need to prove acquired distinctiveness in every country. Now, there's two reasons why they might be walking back. One is that if they don't walk back from the forward options rule in the case of shapes, you're not going to protection for shapes very easily, unless it's used throughout all 27 countries. The other reason, which is hinted at a little bit in one sentence, they say, well, basically, look, if the Germans think that, we assume the Austrians think that as well, which is that maybe shapes is a more European language than our language vocabularies normally suggest in Europe, and that therefore we can assume commonality the way we can't with linguistic and cultural divides that are a little bit more deep. All right. Second example, I'll run through these quickly and then try and get to some of the lessons. So the second example is the protection against dilution, where you have to show a reputation in the community. And in the Pago case, again, it's an Advocate General Sharpton opinion, and the court largely adopts it, though not in as direct language, that basically you can have a reputation in the community even if that reputation is only in a single state, as long as that state is a substantial part of the Union. So Austria, in that case, they didn't actually decide that Austria was significant. They sent that back to the Austrian court to decide whether Austria was significant. Sure. I think it's a hard political question for them to answer. But in any event, the important point of Advocate General Sharpton's opinion is she basically said, take the borders and erase them. Right? You got to think of the European Union in a much more integrated sense. So that, I think, is her vision of Europe, which doesn't have borders. It does have a big lake in the middle called Switzerland, but other than that, it is essentially integrated. All right, and that is a slightly different political vision of Europe that is driving the decision in Pago, and a different, I think, suggests slightly different than the vision that's driving the decision in forward options. So we come back to whether after DHL it's actually as pure as that. Third example is from the case that I started with, Leno. So Article 15 says to keep the CTM, you have to make genuine use in the community. And in the Leno case, which is a trumped-up case from the Benelux, test case set up from the trademark lawyers in the Benelux, the question comes up, what does that mean? And there really are three options for the court justice. They can say, all right, it's enough if it's in one. Use in one country, say the Netherlands, that's enough for the European Union. Use in one state, not enough, it has to be at least two. It's the second option. And the third one is, as you might imagine, typical Court of Justice answer, which is, well, it depends. Right? So one might be enough, but it's not necessarily sufficient in any particular case. So what did they decide? Well, as you probably know, they decided essentially, consistent with Pago, that you disregard the territorial borders. Not surprising, it's another Sharpton opinion. She basically did what she did in Pago. So I thought it was interesting, and this is where you begin to see something you'll also see in DHL, that if you then look at what is the instrument by which they then work out whether genuine use has actually been made out, now that we've got rid of all the borders, they say we need to look at whether in fact it's being used in a way that will cause it to perform its essential function. That is to say, whether it is distinctive. So they're bringing in, to some extent, an intrinsic notion of territoriality in the conditions under which they will look at and assess the question of genuine use. The territorial extent of the use is still relevant. But it's not strong in Leno that that's a modification of the political one, because you could say that that question is still being asked in the context, at least, of the European Union, rather than single country by country. All right. Let me skip one slide and go on to the fourth example, which will get to the most obvious example of illustration of these two concepts coming together. Article 102 of the 2009 regulation says basically when you get infringement, you've pretty much got a right to an injunction, which is a very civilian approach to question of injunction. And the question is, when a court has a CTM, what's the scope of that injunction? Is it the whole of the European Union? To understand that, you need to know one basic rule of the jurisdictional provisions, which is that if a court has jurisdiction in a CTM case on the basis of domicile, either of the plaintiff or the defendant, then in fact the jurisdiction has a political scope of the whole of European Union. But if you sue in the place of infringement, not the domicile, the scope of jurisdiction is just that particular member state. But what did the court say? Well, let me just quickly through the details, but I won't go into quite as much as on that slide. It's a trademark you would have thought could only have been registered at Ohem, but apparently it was also registered in France. Web shipping, for shipping involving the web. And it's almost identical, so if the mark is valid, it's going to be infringed. Goes all the way up. It's never quite clear, classically French opinions, it's never quite clear what they were deciding on what jurisdiction they were even exercising all the way down. But by the time it gets up to the Supreme Court, they're pretty clear that in fact they were exercising international jurisdiction. So in theory, their scope was European Union wide, but the question was, should they therefore grant the injunction over the whole of the European Union? And the answer that the Court of Justice came up with was that you start with the assumption that the jurisdiction defines the scope of the injunction, and the jurisdiction is the whole of the European Union. However, you have to also take into account the territorial extent of the mark that is adversely affected by the infringement, which is a little bit convoluted, but you will see that effectively is, again, the intrinsic notion of territoriality. Where is there, for example, going to be confusion? And there's only going to be confusion where there has been sufficient use of consumer association that you're going to actually warrant, under an intrinsic theory, giving protection. Right? That really explains it in a little more detail. I won't go through that. Here's the example of, in practical terms, where they think you would therefore limit. If, for example, the court has found that there is infringement, but the infringement would only really apply in a single member state because of, for example, the linguistic reasons. So let's assume you have a case where the only people who would be confused are the French. All right? Then even though you have a jurisdiction as a French court to grant a relief through the whole of the European Union, you should shrink. You should take your political scope of territoriality and shrink it to the level of the intrinsic scope of territoriality, i.e. to say where there would be confusion. All right, so you see what the court is doing is blending two different notions of scope to come up with a particular rule, and that ends up with a couple of odd strategic opportunities actually for lawyers. So this is a case that actually was before DHL, but that shows this, and that is that in this case, a CTM case, Rodeo Drive for sunglasses, Christian Dior is sued in France and prevails. No infringement. Then the German licensee of the mark owner brings the action against the same Dior goods against the Dior distributor in Germany. Same mark. Now, I think under decent common law notions of res judicata, that should not really go very far forward. But in fact, given different res judicata notions on the continent, and given the interpretation about what had been litigated in the first case, the German court said, well, you know, the French court, okay, it was a CTM court, but it was a French CTM court. It was a French judge sticking out his European hat. And when he decided that, he was pretty much saying the French were not going to be confused. I mean, how would he have known how the Germans were going to be confused? He's French. All right? So that's all he was deciding. And we can therefore now decide the case de novo for the Germans. All right. Now that's not actually an unnatural. I mean, there's a logic to some of that. The CTM judges we apply are indeed the national judges, just wearing a different hat, a different wig in some countries. It has strategically interesting opportunities for claimants that if they restrict the scope of their first cause of action, they can cause a whole bunch of trouble to defendants by suing serially in a number of different countries. And if you really want to sell throughout the whole of the European Union, you'll need to win in one of them. So the DHL court decision has problems on its own terms. But if I go back to the paragraph that I think is key, which is that when they worked out what the actual rule should be, they thought the scope of a CTM is defined both by the political authority of OHIM and of the CTM courts, that is to say the jurisdiction that's been conferred on the court, and also by the realities, right? The realities on the ground about where confusion would likely occur because, for example, of particular linguistic connotations. All right. Now, how many more minutes have I showed? Another 5? Do you know more than that? Let me skip. I had, but I'll just try and summarize briefly. Max Planck study, which I don't know if you saw, you may have seen today that apparently they're already leaking. The proposed reforms of the regulation have been revealed to the World Trademark Review in leaked documents. It's very high-stakes espionage to work out what the hell the Commission can do with the 2009 regulation. But these proposals, as far as I could see from the free version that I have of World Trademark Review, which didn't give me all the documents, are not going to be implemented, from what I can tell. But the Max Planck study was quite mixed up in the sense that it made a variety of proposals, some of which went closer towards a politically unified market and others that recognized the realities. So this first one, which they proposed actually before the Chocolate Bunny case came down, would actually move away from the options rule in the case of acquired distinctiveness, recognizing they were being driven to it not by any grand vision of Europe, but actually by the reality of the need for CTMs on shapes, which they thought were being precluded by the inability to say, look, it's got acquired distinctiveness in Europe. Okay, it's made it not to Finland, but everyone in Germany and everyone in Spain, everyone in France, everyone in Britain pretty much gets it, that this is actually pointing to a single source, right? So they said that should be a sufficient, strong endorsement of unitary principle. They also, however, came up with a proposal for a coexistence rule for good faith remote local uses that is a derogation from the unitary rule. And then, just to show you in between, their proposal on what unreserved rights may be a hindrance to the CTM in the revision of Article 8.4 was going to be a movement back towards unitary. So they have a variety of sort of different philosophies they were pursuing. There's no coherent vision. My question, and we may come back to that conversation, I don't want to spend more time on it. What I wanted to leave with just the last 5 minutes was, if you have all these sort of different conceptions of territoriality flowing around in the court's case law on the meaning of what is a unitary right, does that give us any insights into broader questions about the meaning of European trademark law? Or is it just interesting on its own terms because this was an important innovation that the CTM had introduced, in which several regions are now wanting to follow? That is the notion of a unitary trademark right. Well, the first thing I think it brings into quite stark relief is exactly whether trademarks, which in common law countries we tend to think about, particularly use-based countries, but even common law countries that have become registration-based countries, we tend to think of as essentially coming to do with consumer protection as a primary justification, and trade regulations sort of sitting on top of that to provide certainty and to sort of oil the wheels of trade. But in fact, if you buy the strength of the political territoriality, then what you should be saying is, in fact, I'm going to insist, for example, that you only need to use in one country because that is the way in which there will be a unitary Europe, a single market, most easily achieved. And that's the trade or economic or industrial policy that's driving this particular grant of trademark right. Likewise, in the DHL case, you said grant European-wide injunction. Okay, so the Germans don't actually need it. What's the harm? Right? This means if they actually want to start selling in Germany, then in fact it's going to be easier, right? Because we have one single producer able to provide rights throughout the whole of the European Union. The second theme that comes up is the extent to which we will inevitably have to moderate the goals of economic policy by the realities of the marketplace and whether or not goodwill does exist or doesn't exist. Now, the case that shows that most clearly is DHL, but I said Pago actually would show it a little bit. If you look at the Max Planck study's interpretation of Pago, they said, okay, Pago, they got the status of being a mark with a reputation in Austria, but they would only probably have gotten relief in places where there was, for example, blurring or there was taking unfair advantage, and if they didn't have a reputation in, let's say, Portugal, they wouldn't have gotten relief from there. So it's actually, Pago is actually quite similar to DHL in terms of the moderation of the territorial political authority by the reality. Well, that actually is something that is coming up in other areas unconnected to territory in the European Union at the moment. And the case where I think this is going to be played out, although the other example at the moment, is a Specsavers case, which is a case on reference from the English Court of Appeal to the Court of Justice at the moment. The question whether, even though the registration is of a particular scope, in this case it didn't have any color delineation, can you take into account the fact that in real life the symbol did have color? So is the bit of property you get from your trademark registration defined by the bit of paper, or is it defined by the marketplace? Right? Now, a real registration system says it's the bit of paper. Right? A system that is coming at the angle more from goodwill, protection, source identification, will want to ask the real life questions a little bit more. And so that's what's being asked. That moderation of the bit of paper is to some extent a mirror image of some of the issues that I think are going on a little bit in the DHL and the pure territory cases. All right. Last couple of points of things to throw out, because these are also inchoate, and then we can have a conversation. I suggested that if you really wanted to move, way back in the early slides, if you really wanted to change the territorial nature of trademark rights and expand them to political borders divorced from market realities, you had to effect institutional political change. It wouldn't just happen because we're a more integrated world, because the ultimate reason for those rules are the national nature or the political nature of the institutions. We've done that a lot in European law. We've created economic policies largely set, at least in reason of trademarks, at the European level. We have OHIM granting as an independent agency of the European Union. The weakness I think we have still is that when we call the courts deciding cases involving the CTM and infringement CTM courts, but they're not. They're national courts. I think it is very, very hard as a matter of judging to ask national judges who look at things through a national lens in the morning to suddenly become a European consumer in the afternoon. And this raises the question, actually, which Jennifer, among others, have written about in the past, which is the extent to which the consumer who decides in some part all these cases is in fact a truly fictional being trying to implement a series of normative policies, which may be, for example, a single market throughout the whole of the European Union, or whether in fact it is an empirical being to some extent grounded in marketplace realities. Even if we do some sort of rough justice, and particularly if we ban surveys, we'll be doing even rougher justice in working out what exactly is the empirical measure. So I think it raises that question of the normative versus empirical nature of the confusion analysis. The last one I'll throw in there, which I think is intriguing because it comes up in a couple of different areas, again, outside questions of territory, is the inevitable convergence through court decisions of the continental tradition and the British tradition towards trademarks. The old way that, and the way that in theory we still do recognize both political territoriality and intrinsic territoriality, is that we have trademark law and then we have passing off. So trademark law does the paper rights, and passing off does the real life rights, the goodwill, protecting the consumers. And it's the interaction of that system that actually covers all the bases. Passing off was not harmonized. The paper rights, the registered trademark, was harmonized, but passing off was not harmonized. Unfair competition was left to the member states. One of the effects of bringing in, increasingly as the Court of Justice is doing, is actually in a strangely British way, bringing some realities in. It's actually bringing in to some extent passing off concepts where you actually have cases on restrictions, for example, scope of relief. It's bringing off, passing off notions to some extent into European trademark law, giving it more political authority over that type of case than would be the case if you left that entirely to passing off. And that, I think, mirrors, for example, what is done on the other end of the scale in interpreting Article 5.2 of the directive, where formal unfair advantage cases would, I think everyone thought in 1989, largely be dealt with under national unfair competition laws, parasitic behavior and what have you. But the way the court has read Article 5.2, particularly in the L'Oreal case, is to bring within trade law proper a series of concepts that really are unfair competition concepts. As a result of which, it is again grabbing a bit of national unfair competition law for itself. So I think I see a little bit of that also happening as a inevitable converging of a series of unfair competition concepts from different parts of the European Union with the proper registered trademark rights concept. All right, so I've gone a little bit over, so I apologize. But with that, maybe I'll just take questions or thoughts, reactions.